Okay, we'll take up the next case of Sterling Terrace versus Florida Housing Finance Corporation. Okay, you may proceed.
Good morning, Your Honors. My name is William Belenke. I'm with the law firm of Manson, Bolvis, Donaldson, and Varn, representing the appellants.
Could you pull the mic down just a little bit?
Yes, sir. I'm sorry. We would like to reserve 5 minutes for our rebuttal time. And one other procedural matter. This case, we asked the court to change the order of arguments between Sterling Terrace case and the Madison Oaks case. And the reason for that is that the second issue in the Madison Oaks case is the only issue in this case. And we thought out of judicial economy, we would argue the issue one time, and then you would simply move on to the Madison Oaks case and resolve the remaining issue that's in that case, and thereby hopefully save the court additional time. May it please the court, this is an appeal from a final order of the Florida Housing Finance Corporation decision to award federal funding to an applicant named HTG Creekside for the, quote, development of an affordable multifamily housing located in the medium and small counties. And multifamily is a term of art, really, that they are building affordable housings for family units. There's aged, there's other classifications, but this is about a multifamily housing development, which by definition will have children in it. In doing so, Florida Housing did not award funding for the appellant's project, Sterling Terrace, that was next in line in the lottery to receive funding. We all equally qualify, and the deciding factor is a lottery to pick among those applicants who are fully qualified. If an applicant is found not to be qualified, it literally drops out of the sequencing order, and the next qualifying applicant, which in this case would have been Sterling Terrace, we would have moved up for funding. Were the court to affirm the final order of Florida Housing's qualification of Creekside, the appellants would certainly go unfunded, but the real losers in this matter will be the children who prospectively will be deprived of unfettered access to charter schools within the proximity requirements for federal funding. For an applicant to qualify for funding, it must establish certain proximity requirements to be competitive. To earn 3 points, which was necessary in this case to become a tie applicant, to earn the 3 proximity points, the applicant must identify a public school that is within the range of less than 1 mile and greater than a half a mile from its development, and that's in the RFA on page 92. If the school that was selected was less than a half a mile, 4 proximity points were awarded. Basically, the closer the school is, the more points it's awarded. If it was above 1 mile and less than a mile and a half, it would be 2 points, in which case that applicant would not have been competitive. The sole question on appeal is whether Manatee Charter School, the school identified by Creekside, met the definition of public school as set forth in the request for applications. The RFA uses a definition that's separate from and different from the statutory definition of public schools found in Section 1002 of the Florida statutes. The RFA uses the definition that is separate from the statutory definition because the RFA has a different intent. And the intent is to qualify admissions so that children residing in the proposed development will have unrestricted enrollment rights in that school. Basically, you walk up to the door, you get in. To resolve the only outstanding question on appeal is whether Manatee Charter School met the definition of public school in the RFA.
Could we let me just ask a question about the
Certainly.
evidence. The representative of the charter school testified, and basically, as I understood her testimony, it was anybody that shows up, we let them in. We don't have any requirements. We don't have a geographic requirement. We don't have a testing requirement. If you show up and you're the right age for our school, you get in.
That's not quite what she testified to. Part of what you say is true. What she testified to is if you lived in Sarasota County and wanted to attend the school in Manatee County, there was not a prohibition, not a distance prohibition. You could apply to get in. But she also went on to say the proximity requirement, in other words, if you are within the proximity of the school, you automatically get in. She said that's not the case. As a matter of fact, she also said that there are other requirements that preclude someone who would live in this development from attending the school. What she went on to testify to say that there were at least preferences that were issued to put people ahead of you in line. Let's say you bring your child to my school. Before I let your child in, if there's an active duty military person who has a child that wants to attend the school, they will get a preference over you.
But isn't that applicable only if the school was at capacity or near capacity, which apparently this school never had been, so they had never had to turn anyone away?
Well, I don't know if the
And
record...
don't we measure that as of the time the application's made, or at least as of the time they make the decision on the application?
Well, but the problem, no, that's not the way it works. The way it works is, regardless of the time, if 5 years from now there's a student that wants to go to that school, because it's not going to be right now that the development is even built. So the school has to be available to the children in that development prospectively. So you have the military preference. You have preferences for children who have siblings already attending the school. And you also have preferences for children who are the children of board members to the school that will all come ahead. And then of the remaining vacancies, there's a lottery, and you don't know if you're going to get selected through the lottery. So there's not an open enrollment policy here at all.
Well, what does the third sentence in the paragraph in dispute mean? It says, additionally, it must have been in existence, referring to the school, and available for use by the general public as of the application deadline.
Yes, the first part of that...
So existence, the charter school did exist.
Yes, the first part of it is correct.
What does available mean?
Well, it means exactly, you have to look at the first two sentences. And what the first two sentences say are really the crux of this case. It says, the first sentence says...
Well, before you get to the first two sentences, the reason I asked about that is Judge Orfinger mentioned that you look at it at the time of the application or the time the decision's made, and you suggested, no, you look at prospectively. Because even a public school, if this was the public school that relied on, the neighborhood, I mean, it could have a lot of kids moving in the neighborhood, and if you're a mile away, you might get zoned out. So prospectively is always going to be somewhat speculative.
Well,
So I'm asking you what available means. I mean, do you look at what's going to happen 5 years down the road, or do you look only at the time of the application?
Well, what you're looking at, and let me clarify that. What you look at the time of the application is, does the school have an open enrollment policy? You don't look at how many vacancies it has at that moment, but you look at whether it has an open enrollment policy. And that is, if someone from this development walks to the door at that time, does it unquestionably get a right to attendance? And in this case, it doesn't have an unquestionable right to attendance because there are preferences ahead of it, and it's basically fact-driven. You don't know what the vacancies are at the school, but the rule has to be that if there are vacancies, our children walk up from the development, walk up and have a right to attend. They can't come in behind a line of someone else who has a preference, and it can't be subject to any other qualifications like a lottery. And that's where you get to the second sentence, which the ALJ said applies to this school. And in the second sentence, it says, this may include a charter school if the charter school is open to appropriately aged children in the radius area, half a mile to a mile, who apply without additional requirements for admissions. And then there is a non-exclusive list that says, such as passing an entrance exam, an audition, payment of fees.
What does the word "this" define? Does it define a public elementary, middle, junior, and/or high school, or does it define a public elementary, middle, junior, high, and/or high school where the principal admission criteria is the general proximity to the school? Which one does it define? What does the word "this" define here?
The this that starts the second sentence, it means that if you have a charter school that is a
Well, you could
junior
agree,
high school charter
if,
school.
if they had done what English teachers drill into you in a high school, if they had defined this, they could have defined this as a public elementary, middle, junior, and/or high school, or they could have defined this as the entire sentence.
Well, the thing that I just read a great article in the Bar Journal about the use of the word "and/or," and it said, don't ever use it.
That's a separate issue there. But, yeah.
Well, but as it applies in this sentence, though, it says a public elementary school, or a middle school, or a junior high school, or a high school. So this can mean a charter school that is any one of those, or a combination of them. And so that's how I read the two sentences together. That this may include a charter school that is an elementary school, or a middle school, or a junior, or high school, or any one of the combinations, without additional requirements for admissions. And what you have, if you go back to the deposition of Mrs. Quajones, when she testified under those qualifications, she said, we don't use geographic proximity as the sole guide. In other words, those who are closest don't necessarily get in. You can be from Miami, and if you wanted to go to this school in Manatee County, you can schlep yourself over there and go. But that's not what this was intended to do for the purposes of getting federal funding. To get federal funding, this had to look like a public school. And there are certain charter schools that statutorily meet this definition. And those are charter schools that the ALJ didn't even concentrate on when she created this fiction that somehow that this charter school only had to meet the second sentence, because to do otherwise would preclude all charter schools from being considered eligible for the issuance of proximity points. The statute itself said if the charter school was once a public school, then it has to maintain the same admissions criteria as if it were a public school. And therefore, her whole basis of her decision was based on an incorrect reading of the statute. And she was legally incorrect and clearly erroneous. Now, even the council for Florida Housing, when the issue came up for discussion before the board, agreed that the ALJ's conclusion was clearly erroneous. And what further complicates the matter is this issue of the discrepancy between the first and second sentence was never an issue at the trial. All of the parties agreed, and even the appellant's counsel in its brief said all of the parties agreed that this was not an issue. It first becomes an issue when the judge, the ALJ, goes off on some mission of discovery to try to find a way to reconcile these sentences when everyone understood the meaning of them, that they were to be read together. And Manatee Charter School, unfortunately, didn't qualify under the first sentence or the second sentence. So it didn't qualify as being eligible for any proximity points towards qualifying Creekside for funding. But she couldn't rest there. She couldn't just rest on the idea that there was a discrepancy in the two sentences, but she had to create an evil, and the evil that she created was, if you read the definition this way, all charter schools would be eliminated from consideration, which simply isn't true. The Florida Housing has, for 15 years, understood what this definition meant. For 15 years, it has allowed charter schools to be considered for the issuance of eligibility points. And for 15 years, everyone appearing before Florida Housing knew what it meant. And the ALJ just went off on her own tangent and tried to reconcile the difference. I see I have 5 minutes left. 2 points. One, what the board did was in violation of the statutes and that it changed its policies, and had it based upon an unadopted rule. It now said that all charter schools meet this definition automatically. That was a violation of Section 12057(1)(e)(1), which really prohibits the use of unadopted rules as a basis to affect the substantive interests of a party. And I think the court, when counsel for Florida Housing comes up here, should ask Florida Housing's counsel one question, and that is, counsel for Florida Housing cannot come up here and refute the following conclusion. The record shows that as of the deadline for the filing of applications, no child in the proposed Creekside development would be able to attend Manatee Charter School without being behind other student preferences and subjects to an admissions requirement.
But don't we have to look at the evidence? I mean, the evidence from the lady that testified was, yes, we have preferences for certain people, but we've never had to use a lottery or anything else because we've never been at capacity. So while there is a theoretical possibility that a child from the development could get turned away, don't we have to actually examine the evidence that was introduced? And the evidence introduced says, as of the date, the relevant date, if you knocked on the door and you were the right age, you got in.
Well, no, Your Honor. You look at the admissions criteria at the time of the application. You have to meet the admissions criteria at that time, regardless of whether you have vacancies or no vacancies. Because what's to stop growth in the area so that next year when the development is done, all of a sudden applying those criteria preclude the admissions to these
But
child
that would be true for what the ALJ referred to as a traditional non-charter school as well. I mean, the school board could change the zoning tomorrow if they wanted to. They're not concerned with the Florida Housing's projects. I mean, I guess they think about those things, but I mean, they could change that. We can't really worry about the prospective. I mean, we're looking at the application date or the decision date. And don't we have to look at the evidence to see if there was competent evidence? Then the evidence was there's room for these kids.
Well, then Florida Housing should write in the definition of the public schools a condition that says, as of the date of the application, this rule only applies if there aren't vacancies within the school, and it didn't say that. What it says is,
everybody agrees that the purpose of the rule is to make certain that there's room for kids at the neighborhood school.
correct.
And if we examine the evidence, doesn't the evidence demonstrate that there's room for these kids at the neighborhood school?
Today, but not necessarily when the development is completed and families move in and there are children.
How would that be different with a non-charter public school?
Well, in the county that I live in, what happens is when the school gets to capacity, they move another mobile unit onto the lot, and those children still get to go to that school.
Yeah, but alternatively, they could have an undercapacity, a school under capacity 5 miles down the road, and they could change the zoning and put those kids in with the school 5 miles away.
But we're talking about qualifying a development for federal funding, and we have certain requirements for federal funding. We're not a public school. We are saying to the developer, locate your development where there are ready, accessible services like hospitals, like medical facilities.
And was the school readily accessible at the time of the application and the decision?
It was within a half a mile and a mile, and so it was identified as being an eligible school, but it didn't meet the eligibility requirement for attending. And that carries forward prospectively.
Well, doesn't that depend on how you interpret the word "this," whether this defines the first half of the first sentence or whether this defines both halves of the first sentence?
I don't think it does, Your Honor, because this, whatever it defines, says that you cannot have additional qualifications for admission other than residency within that proximity of the school.
Okay. All right, we're down to about half a minute.
Thank you, Your Honor. Thank you for the accommodation.
Yes.
Good morning. May it please the court, my name is Chris McGuire. I'm with the Florida Housing Finance Corporation. Florida Housing defines what a public school is in the RFA. It doesn't define it in, excuse me, in rule or statute. And so the question of deference was raised in their reply brief as to, does the court have to defer to the agency's position on something? And if it's a statute or a rule interpretation now, apparently not, with the new constitutional amendment. But there's nothing that says that courts shouldn't defer to an agency's interpretation of a specification in a bid solicitation. And in fact, 12068(7) says that the court may not substitute its judgment for that of the agency in a matter of discretion.
Let me ask you this. Do we take into account at all that the attorney and representatives of the agency took a different view than the board ultimately did? Is that a factor for us to consider? And if so, how?
It seems to me that that's the way the administrative process is supposed to work. That when counsel, which would be me, and our agency representatives went to a hearing, we had an interpretation of what this term meant. And the administrative law judge disagreed with that. So when that goes back to the board is now in a position of saying, well, we could overturn the administrative law judge's conclusion if we find that ours is more reasonable, but we don't. We accept in this particular case the ALJ's conclusion. That's the way it's supposed to work. It wouldn't make any sense for me to say, gosh, once I have an opinion and once we give our opinion at the hearing, nobody can ever change that. The administrative law judge doesn't have any authority to disagree with us. How could that be? So I think that this case really kind of proves that the system does work. So the ALJ found that the first sentence, which applies to public schools and talks about geographic proximity, did not apply to charter schools. Apparently she read, and the order's not as clear as it could be, but it looks like she read that phrase, "this may include a charter school," to essentially be referring to the term public school. In other words, a public school can include a charter school that does this, that has the radius, area, preferences, admission criteria, and that the first sentence applied to all other schools that were not charter schools. She called them traditional schools. The word traditional wasn't ever in the definition, but she looked at that as being other than charter schools. So the second sentence with the criteria for charter schools stood on its own. And she had a couple of reasons for this. The first is, when the first sentence talks about geographic proximity, and the second sentence talks about all children in the radius area, nobody could explain what the difference was. Nobody could explain what a radius area meant. And so she read those as being essentially in conflict. You can't require them to accept all children in the radius area and require that they have geographic proximity as a principal admission criteria. So if the two sentences can't be read together, then they should be read separately. Her second reason for that was looking at section 1002.33, the charter school and school choice statute. And she read parts of that. It's a long and complicated statute. And she concluded that under that statute, no charter school would ever be able to meet the criteria of having geographic proximity as a principal admission criteria. Now, I don't know if she's right or wrong on how she interpreted that statute, but that conclusion of law is over a statute that Florida Housing does not have substantive jurisdiction over. We are not in a position to disagree with her as to how that statute should be interpreted. So even if she was right or wrong, it still formed a basis for her to say the first sentence doesn't apply to charter schools, either all charter schools, most charter schools. It's a problem for charter schools. So when she read them as being separate, she found that there was competent substantial evidence to support her conclusion that the charter school met the second sentence in the definition, and therefore they should be found eligible. It is true that for the past number of years, charter schools have been accepted, magnet schools have been accepted. We have never had litigation over what a public school means, at least not recently, and it never directly involved a charter school as far as I can tell. But that doesn't mean that everything we say is right all the time. That's never been litigated. No one's ever brought this to our attention and challenged us in front of an administrative law judge. So the fact that the first time it appears before a judge, we lose the case, essentially, that's not really surprising. It doesn't, just because we've been doing it a certain way for all these years doesn't really make it right. So that's sort of where we are on this, that the board could have rejected the ALJ's conclusions, but didn't. Could not have rejected her conclusion regarding chapter or section 1002.33, could not have rejected her findings because they were supported by competent substantial evidence. So the board presumably then, after much debate back and forth, decided that the ALJ's interpretation was at least as reasonable as the staff and council's interpretation of it, and accepted the recommended order.
What is the meaning? I'm trying to understand where it talks about in the first sentence where the principal admission requirement is geographic proximity. Schools, as I understand it, school boards frequently design their zones to try to achieve racial balance, ethnic balance, things of that nature. So you don't always have a school right in the middle and then a perfect circle around it for geographic proximity. A lot of times it looks like the maps the legislature comes up with for congressional districts. How does that apply in the first instance, you know, where you might bring in kids from a different zone to achieve a racial mix?
Well, and that's a good question. Our assumption in this is that if you're located within a mile of the school, you are within that school zone and can go to that school. Now, we know that's not always the case. I mean,
That assumes that you got a school and there's a perfect mile circle right around it.
Yes.
And that all of those children are zoned for that school, which may or may not be the case depending on how the school board wants to slice the pie.
That's correct. And as you point out, the school board can change that zoning over time.
Well, a classic example is if you had a major highway, they usually will not put a school. So even if you were a quarter of a mile away, but it's across a major highway, you're probably not going to be zoned for that school.
That's correct. They would still get the full credit, though. The way that we score this RFA, all we look at is the distance from the school. We don't ask them to try and calculate whether they're in a particular school zone, because again, that can change any time.
Now, let me ask you this. The first sentence says the principal admission criteria is proximity. It doesn't say the only criteria. Frequently, schools will have even non-charter public schools will have a situation where even if the school's at capacity, if you have a sibling at the school, the younger sibling is entitled to attend so that parents aren't going to two different schools. So does that sentence suggest, it says where the principal admission criteria, that there can be other criteria other than the principal one? And how does that relate to the idea that the charter school might have preferences? I mean, that sounds kind of the same, that, you know, a criteria and a preference, probably different things. I mean, you could argue that point, but I'm trying to understand, does the first sentence suggest that there can be criteria other than geographic proximity?
I'd have to say yes. I mean, clearly, if we wanted that to be the only admission criteria, we could have said that. Principal admission criteria, that means that there could be other factors. And it could have to do with history of suspensions. It could have to do with whether there's siblings there. It could have to do with a lot of things, I guess.
And as far as the second sentence goes, where it talks about open to appropriately aged children in the radius area, so apparently you all agree the radius area relevant to this is half a mile to a mile.
No. What the ALJ found is that the radius area for the school is Manatee County. Florida Housing took no position as to what the radius area was. In fact, our witness said, I don't know what that means. So the ALJ found that based upon the contract that the charter school had with Manatee County, that the Manatee County was, in fact, the radius area. So if it accepted children from Manatee County, it met that requirement.
So the statute and rule don't define radius area, and the RFA didn't define radius area?
That's correct.
And
It will in the future, but it did not in this case.
well, that's how we learn.
Yes, exactly.
We run into these problems and solve them.
If this had been litigated 10 or 15 years ago, we would be in a different posture today. But, and the question on preferences, I don't exactly know how that would really impede a charter school qualifying for this. But you're right that in this particular case, we didn't have to care about it because this charter school was not at capacity. They've never had to use the lottery. They've never had to use the preferences. So it's all kind of hypothetical at this point.
Never turned anybody away, correct?
Well, I don't know if that's true, but they have not turned them away because they were at capacity or because they didn't have a lottery number or because of where they lived.
And it says, the RFA says, available for use by the public as of the application deadline. So for purposes of how the housing authority or housing commission makes its decision, is that the relevant date that you all consider the application deadline?
Yes, yes, particularly for that third sentence where if there's a plan to school, we're going to build a school in the next couple of years, we don't count that. If there's a school that's been built but it's not open yet, as of the application deadline, we don't count that. So the application deadline is when we look at the third sentence at least, that it has to be open and available.
So in existence is the school exists and available as it's open?
Yes.
Okay.
All right, thank you.
Okay.
Wow. If I were a quarterback, I could get in 8 plays, but I got to get in.
We'll call timeout for you.
Bless your heart. I think you just have to put the proximity question into perspective. We're not looking at proximity to the school. Draw a dot on a map where you're putting your development and measure your distances from that. So you draw a circle that's a mile out, and you draw a circle that's a half a mile out. And if there is a school in there that has open admissions, then you met the requirement for 3 points. If there's a pharmacy within that, you meet the definition for proximity to essential community services, you get 3 points.
You know, the pharmacy, you know, you can choose what pharmacy you go to, but it's kind of strange that on the way they structured it, you know, if you're not zoned for that, if you're zoned for a school 5 miles away, you get the points, or you know, it's just kind of odd, or vice versa. I mean,
Well, you could have the same thing with a doctor's office that's within that range. He may not be taking patients, but if there's a doctor's office in that range,
Yeah.
that's good enough. And that's what this case is about. It wasn't good enough for Manatee Charter School to qualify Creekside to be located at that point. I see I'm well over my time.
all right, well, thank you both.
Thank you, Your Honor.
All right, any attorneys that wish to join us in the attorney lounge can do so. We'll take a short recess.